Welcome to today's programming, AI and Anti-Discrimination, AI entering the arena of labor and employment law. We are happy to have you with us today. My name is Steve Schaefer, and I'm the director of the Federalist Society's Regulatory Transparency Project. In order to get right to the programming, I will keep biographies brief. Note, as always, the Federalist Society takes no position on particular legal or public policy issues. I am pleased to introduce the Honorable Keith E. Sonderling, a commissioner on the U.S. Equal Employment Opportunity Commission. On September 22nd, 2020, the U.S. Senate confirmed Mr. Sonderling on a bipartisan basis to serve as a commissioner on the EEOC. As commissioner, Mr. Sonderling has published numerous articles on the benefits and potential harms of using artificial intelligence-based technology in the workplace and speaks globally on these emerging issues. Prior to his confirmation to the EEOC, Commissioner Sonderling served as Deputy and Acting Administrator of the U.S. Department of Labor's Wage and Hour Division, which administers and enforces federal labor laws, including the Fair Labor Standards Act, the Family and Medical Leave Act, and the labor provisions of the Immigration and Nationality Act. We are pleased to have Commissioner Sonderling give the keynote today. Please join me in welcoming Commissioner Sonderling.
Thank you very much. All right. Well, thanks for having me. I'm really looking forward to this discussion today. And being a part of this panel, I think we're really going to dive into some of the trickier issues moving forward on how you actually regulate this and what businesses should be doing now and what the government's approach should be as well. But from my perspective, I wanted to lay out the groundwork of how AI is being used in HR. I'm going to go over some examples, give you a brief primer on the law, and then we'll get into the panel. So right now, as you all know, AI is all over the news with ChatGPT and everything else. And the reason is because AI is just very fast, it's efficient, it's making business decisions for companies in a way that's making them a lot of money. And that's a really good thing, right? So when businesses use AI in certain contexts and they see it's working, what do? They want more. And then what happens? More investment goes into AI, and you get it into all different arenas in the corporate sector. So whether it's making deliveries faster, widgets faster, you name it, AI is out there. So you have these smart computer engineers in Silicon Valley saying, okay, well now we've, for the most part, figured out how to use AI in business. What else can we automate? What else can we use AI in? Oh, there's HR over there. Well, that seems like a very simple function, right? You know, most of people's experiences with HR are not dealing with the complexities that we deal with at the EEOC. So, it's mainly getting forms, and we can automate some of that. And that's good. Some of that can be automated. But then diving into, well, what is the biggest problem facing HR? And that's the H in the HR, which is the human. Why? Because of the bias that has long plagued human decision makings in our space. One of the reasons that the EEOC exists. So now, how do we eliminate the human from that process? How do we automate that process? And as you'll find out, and as we'll discuss, and as the EEOC has been talking about, that's not a very easy thing to do, especially because here, when you're dealing with AI in HR, you're dealing with some of the most fundamental civil rights we have in the workplace, and that's the ability to enter in the workforce and thrive in the workforce without being discriminated against. So, and when I started talking about AI in HR, or I start talking about this, a lot of people just, their minds go to this dystopian future of these robot armies replacing humans, right? And that has caused, in a sense, for a lot of people to say, well, we don't need to worry about this yet. We're not, having robots in our workforce. And there's a lot of stats that are really out there that are making the news, like the World Economic Forum predicts in the next 4 years, 85 million jobs will be displaced by some sort of AI automation. The Brookings Institute did a study, which I like to cite to, because it looked at the Department of Labor's database. And in the Department of Labor's database, they have around 759 job categories. Of those 759 job categories, 740 of them have some near-term risk of automation. And we're seeing in the news that companies are buying robots. Orders are up 40%, and it's going to be cheap to do that. There's some studies out there that show replacing 2 to 3 workers every single year is only going to cost companies around $10,000. So most of the conversations about AI in the workplace relate to that. Now that I've said it, we're going to completely move on because that's not what we're talking about today. From the standpoint of what I want to talk about today is how AI interacts with workplace anti-discrimination laws. And the issue is that HR departments now, like most businesses, have more information about their individual workforce than ever before. In HR, data is everything. It makes the difference between a good hire and a bad promotion and a good promotion. And what I'm trying to raise awareness of in this space is the difference between lawful and unlawful decision making. And the HR tech market, the spending is just tripling. It was $17 billion in 2021, and that's expected to go up to $30 billion. So it's out there, it's happening. It didn't happen overnight. Whether you're aware of it or not, AI is being used in the entire employee life cycle. From the very beginning to write job descriptions, AI screens resumes, it chats with applicants, it conducts job interviews, it predicts if an employee will accept the job they were offered, and then how much you have to pay them to get there. There's even programs out there that will tell you, okay, once this employee has now started, this is where they should sit. This is who they should interact with. There's software out there that identifies employees' current skills and potential skills. There's software out there that tracks employee productivity. There's sentiment software that every day will tell you if your employees are happy or not by looking at their Microsoft Teams or in their Outlook. And there's also software out there that if you fall short of your expectations, you get a message saying you're fired. This isn't my forward-looking prediction for each of these softwares. In all seriousness, there's thousands of programs out there for you to buy with a lot of vendors happy to sell them to you. And the reason that we're seeing these being so infiltrated so quickly is a lot of them promise to advance diversity, equity, and inclusion by mitigating workplace bias. So a lot of the larger companies that can afford this software, whether they're buying it on the outside or building it internally, when you say, help me with DE&I, we have some programs to do it, how many millions of dollars can we give you to do that? So now deciding for these companies whether or not to integrate AI in their HR systems is no longer a question. The question now is how do you implement them? For what purpose are you going to use it? And more importantly, how does it comply with long-standing employment law? And whether or not, it's a discussion for another day, whether this is a good thing or a bad thing, whether HR should be completely replaced, that doesn't matter to us, at the EEOC. But from my perspective, if AI is carefully designed and properly implemented, it really can help companies with their push to advance diversity, inclusion, and accessibility in the workforce by mitigating the unlawful risk of discrimination. So as most of you are attorneys in this room or close to this area, you know that workplace decisions have been vulnerable to bias. Again, what my agency does and why we collect around $500 million for victims of discrimination every single year. But there's some really basic studies out there that, bias at the earliest stages of the hiring process. So a male and a female submit the same resume, a male is more likely to get selected. There are studies out there that show if African Americans and Asian Americans whiten their resume, and what do I mean by that? They just remove any characteristics that would show what their status is, racial references, ethnicity. They receive more callbacks than when they're not on there than when they are. So a lot of times companies just don't become aware of this discriminatory conduct until it is too late. And this is where really AI can come in very early and eliminate bias at the earliest stages of the hiring process. An example I like to use because it's very simple, you think about an applicant's name. An applicant's name, what does it tell you about the employee's ability to perform the job? Absolutely nothing. But what it does tell you is a lot of potential protected characteristics that the EEOC says you're not allowed to make a decision on, such as the applicant's sex, national origin, religion, or race. Likewise, there's a lot of programs out there that your first interview with a company is done completely on an app. So, when you walk into an interview, whether it's now on Zoom or in person, that person who's interviewing sees a lot about you, right? They see you. And again, all those factors, you cannot make an employment decision on. So it can help with intentional discrimination at the earliest phases of the hiring process because if you're looking at the words the candidate says, how they're responding to your question, you can't see them. You can't see that applicant is a certain race, national origin. You can't see that they're pregnant disabled, or religiously observant. Because no matter what, you have two candidates. How do you know if a hiring manager just doesn't hire somebody who's not disabled and goes with somebody else and say, well, you're equally qualified? You don't know that decision, because they'll just say we went with the more qualified candidate, but in reality, they may have been making that unlawful decision. So at least, using AI at the earliest stages, that doesn't happen, and that person can get further than they were before. So now I'll flip everything I just said, and at the same time, if AI is poorly designed and carelessly implemented, it can discriminate on a scale and magnitude far greater than any individual HR professional. Because like any bad HR decision, poor uses of artificial intelligence can damage the trust in the organization that uses it, create a toxic culture, and then hurt the profitability of the company, which is why the AI programs were bought. So AI is only as good as its purposeful and insightful application by the companies that are actually using it. And the big part of AI, and this is not unique in the HR space, it's just easy to understand in this space, AI is only as good as the training data on which the algorithms rely. And what does that mean in our space? It means who's the applicant pool, who are the employees. So for example, an algorithm that relies solely on the characteristics of a company's current workforce to model the attributes of the ideal candidate will just replicate the status quo. So if a workforce is made up of primarily of employees of one race, gender, national origin, you pick the protected characteristics, the algorithm is going to just automatically screen out those people. And the most infamous example of this point, and it's widely used in the AI space, and who knows if it's even truer anymore. The legend goes that one of these companies went to an AI vendor to diversify their workforce, and they said, here are my best people in this position. Go use your fancy machine learning, your fancy computers, and find what makes them so great. Without bias, let the computers make that decision. And the resume screening company using AI used machine learning, look at the patterns, and they came back and they said the most likely indicators of success at your company is being named Jared and having played high school lacrosse. Now, a lot of you may have heard this one already because it's widely used, but it just shows you why that was, because that's the pool they were looking at as well. So at the EEOC, our mission is to prevent and remedy employment discrimination and advance equal opportunity for all in the workplace. Many of the laws that we're going to discuss predate AI by over half a century, but it's really important from my position to make sure that anyone who's using AI or being subject to AI know that these laws apply equally to AI systems as they have been since they were enacted in the 1960s. So I need to just give a brief law school lesson here for those of you who don't practice labor and employment law. Then I promise I'll give you some examples, and Aram can grade me because he is a dean at GW. But essentially, to keep it simple, there's two theories of discrimination under our laws: intentional disparate treatment and unintentional disparate impact. And one requires intent, one is based upon a neutral policy that winds up discriminating. And what's really important in our space is that liability, for the most part, is going to be the same either way. So really, really simple textbook examples: a disparate impact. A company just wants their workers to come to work on time, so the only qualification to work at this employer is living in the zip code next to the office. We don't care anything else about you, you just have to live in the zip code. Well, if the zip code is predominantly made up of a certain race, sex, national origin, it's going to have a discriminatory outcome there. Intentional discrimination, disparate treatment, very simple. I'm going through resumes. This resume is of a woman. I don't want to hire any women. Right in the trash. Very easy. So how that applies to AI, and we don't have a lot of examples of how AI is actually cases that we can report upon and discuss, and during our panel we can talk about some of the reasons that might be, is for the disparate impact and unintentional. There was an alleged, now widely used story from Amazon that they created a program to rate resumes for a certain position, and they used the training data on everyone who applied and was accepted to the job in the past 10 years. So they ran the machine learning, and then the computer was asked to rate the applicants from 1 to 5. If you were a woman, you were automatically rated lower than men. And they looked at that and they said, well, this is a function of the training data set because there wasn't many women in the data set, so automatically it looked and downgraded you based upon that characteristic. And this wasn't a proof of misogynistic intent on behalf of the AI. It was a function of the data fed to it in the first place. So most people in the AI community, whether you're talking about AI in employment, whether you're talking about in housing, insurance, you name it, use that example specifically, just basically garbage in, garbage out. Pretty simple. It's used widely to show how AI can discriminate. But what's not talked about is often, and what I'm trying to raise more awareness of, is AI being used to intentionally discriminate. Now you may say, well, how can AI intentionally discriminate? Because it's, there's no human involved. It's just making these decisions based upon those patterns. Well, it can, and this is something, that when we talk later about some of the best practices of who has access to the system, because there's nothing preventing somebody to then go inject their bias into the AI system and then scale discrimination far quicker than throwing one resume in the trash. So an example of this is a case not filed by the EEOC. It was one that the ACLU brought against Facebook and other companies relating to their online advertising practices. There it was under state age discrimination law, where they said employers could use Facebook's tool that they use for other kinds of advertisements for products, which they can very specifically limit and show you the products, and that's how Facebook makes a lot of money in that way, but doing that for employment advertisements. And there it was alleged that it was limited to certain age groups. And the difference between advertising a product and advertising a job is that those are federally protected and you can't discriminate. So there, if you weren't in that specific age group, even if you were qualified for the job, you didn't see the advertisement based upon being in that protected characteristics, which was done through clicking and having the algorithm sort it that way. So the case settled pretty quickly, and again, we weren't involved in that, and they said they were going to take down the portal. But it's a good example to show with how, just a few clicks, how discrimination can be scaled here intentionally. And even worse for the victims of discrimination, those who are on the other side, it goes even further than some of the pre-civil rights job advertisements that we saw before. So, a lot of you have seen the historic black and white photos of job advertisements. If you haven't, just Google pre-civil rights job advertisements. They're pretty, very, I don't want to say funny is not the right word, because at this point it is funny looking at them, but they were serious job advertisements. And the famous one was, no Irish need to apply. You've seen that in the black and white photos in storefronts. Well, at least there you knew you were being discriminated against because of your religion. You knew that job opportunity was not available, and if there was civil rights at the time, then you would be able to exercise those. Here, it goes even further because it withholds the very existence of the opportunity based upon your membership in the protected class. So all those individuals who didn't see that potential job advertisement, who were qualified for the job and who would have applied if they weren't screened out because of their membership in a protected class, could potentially have been involved in that case. So you see how quickly these cases can get very large. So going back to the example that I gave you before, and with each of these you have to look that there's significant benefits to them, but there's also significant risks as well. I said a lot of companies are using, your voice or the way you respond to answers, not the way you look during these interviews. So on an app, they look and use machine learning through natural language processing, all the fancy buzzwords, to see the order in which you are answering questions. And again, that could be a really good thing because it can help have employers take that skills-based approach, which they're all looking to do, saying, here's how you responded to the question, and we're going to have our machine learning go rate you based upon the words you're saying. Well, the issue there is if the transcription can't pick you up, let's say because you have a heavy foreign accent or you're disabled. So if I have a thick foreign accent and I give, responses and it only picks up 50% what I'm saying and I'm rated at below 50%, but somebody who speaks fluent English, it gets rated at 99%, even though I was saying, better responses and I'm more qualified for the job, I will be lowered basis upon my national origin. Or if I have a disability, if I slur or stutter, and then the computer can't pick me up, I'm also then being judged there as well, and that's disability discrimination. So you can see with each of this how careful employers have to be both on the purchasing side and the implementing side, because each of them can actually help remove bias, but also increase bias as well. And I will conclude with one more example before we get to the panel, is that now with people returning to work, a lot of employees have gone to having some of the HR managerial functions done by algorithms. So your only point of contact may be with a chatbot, and that chatbot is telling you what to do that day for work. And that chatbot is telling you how many deliveries you need to make or how many widgets you need to make, which is fine. It can help, make things go quicker, more efficiently. But at the same time, if it's automatically rating you without some kind of human intervention, or in the AI world, human in the loop, then it may not know that you're struggling that day and not hitting your goals and automatically lowering your performance review because of a disability, because of a need for a religious accommodation or because of a pregnancy, all things, which human managers walking the floor would see. And under the Americans with Disability Act, the manager or the HR department would then engage in the interactive process under the ADA to make sure they can have an accommodation while they're doing their job to perform at the same level. And there's not an algorithm sophisticated enough yet to know that this person is not performing well that day because of a disability or because of a need for accommodation that human touch, that human element would be able to find. So, this really, tees up the important questions for employers, for companies, for designers, developers of, what programs you're going to build, and more importantly, how they're going to comply with our longstanding laws. Because, as I like to say, our laws may be old, but they're not outdated. They're applying equally to decisions made in the 1960s with pen and paper as they are now to these products that are being developed, being used, or haven't been developed yet. And that's really important not to lose sight of, because from an employer's perspective, whether or not you intend to discriminate, if there is discrimination, that's what we're going to look at, whether it's done by a human, whether it's done by a computer, or a combination of both. And employers can't lose sight of that, especially some of the way that these programs are being sold. So I really look forward to our panel now. I hope this gives you enough information on how AI is being used in HR and some of the high-level legal issues, and now we'll dive into some of the fun stuff. So thank you again for having me.
Thank you, Commissioner. Now I would like to introduce our panel. I will keep my introduction short to get right to our discussion. I would like to note before we begin that we take intellectual diversity very seriously, and we did have a confirmed left-of-center speaker who declined to participate more recently. After our discussion, there will be the opportunity for audience Q&A at the microphones that you see at the either side of the room. We welcome Philip Miscamera as our moderator today. Mr. Miscamera is a partner at Morgan & Lewis, where he leads the firm's NLRB special appeals practice and is co-leader of Morgan Lewis Workforce Change, which manages all employment, labor benefits, and related issues arising from mergers, acquisitions, startups, and related issues from workforce reductions and other types of business restructuring. Mr. Miscamera served as the former chairman of the NLRB under President Trump. Prior to becoming the chairman, he was appointed to the NLRB by President Barack Obama on April 9th, 2013, and was approved unanimously by the Senate Committee on Health, Education, Labor, and Pensions on May 22nd, 2013. He was confirmed by a voice vote in the U.S. Senate on July 30th, 2013, and served from August 7th, 2013 to December 16th, 2017. We welcome Aram A. Gavor. Mr. Gavor is the Associate Dean for Academic Affairs at the George Washington University Law School and a nationally recognized scholar in the fields of administrative law, federal courts, and national security law. Mr. Gavor was an advocate in the Civil Division of the U.S. Department of Justice and in private practice. Associate Dean Gavor has litigated federal court appellate and trial cases involving high-profile challenges to statutes, regulations, and policies. He received the Attorney General's Award for Distinguished Service in 2019. We welcome Mr. David Fortney. Mr. Fortney is a co-founder of Fortney & Scott LLC, a Washington, D.C.-based firm counseling and advising clients on the full spectrum of workplace-related matters, including employment discrimination and labor matters, compliance programs, government contracting, international dispute resolution, and developing strategies for avoiding or responding to workplace-related crises. Mr. Fortney previously served as the Chief Legal Officer of the U.S. Department of Labor in Washington, D.C. during the term of President George H.W. Bush. Please join me in welcoming our panel.
Good afternoon, everybody, and welcome to our panel discussion on the impact of artificial intelligence on employment and human resources issues. Today, we'll be discussing everything from the ethical considerations of using AI in hiring and performance evaluations to the challenges of upskilling and reskilling a workforce in the era of automation. So sit back, relax, and enjoy the discussion. And remember, if a robot asks you to hand over your job, just say no. Here's the question. Did I write that introduction, or was that introduction written by ChatGPT? I'll tell you, it was a 32-word request to ChatGPT, only edited for the sake of brevity, which I'm not normally known for. Here was the request. Write an introduction I can use as a moderator of a panel discussion on the impact of artificial intelligence on employment and human resources issues, and include some humor in the introduction. And so, as to the joke, which, by the way, some of you laughed at, if a robot asks you to hand over your job, just say no, I would give that a B+. However, it's humbling to think that an algorithm in about 10 seconds, based on a 32-word request, could have written the same type of introduction that I would have written in my case, which involved 4.5 years of serving as chairman or board member on the National Labor Relations Board, 40 years as a labor and employment lawyer, participation in a symposium at MIT on artificial intelligence, and 8 years of college and graduate school. I keep wondering, what could I have spent all of that time doing if I would have only known that ChatGPT could have performed the way it did with respect to my 32-word request. So, in fact, we do have a great panel, and I'm just going to move on to the panel, and then we'll ask some questions. And we're going to start with Aram Gavor. Aram?
Thank you. Pardon me standing, the professor and appellate advocate in me thinks better on my feet. Thanks so much, Philip. Thank you, Stephen. And thank you to the Society for putting together this really thought-provocative discussion today. My perspective will be that as an administrative law federal courts generalist, and I specialize on artificial intelligence issues as well, tech in the law. So to be very clear, I am not an employment law expert. But I think there's a lot of really critical and important information to be gained to consider the milieu, the background upon which these discussions about AI and HR are happening. At the federal government level, we don't have a statutory body that has been enacted by Congress that governs the subject matter. Some would argue that we're very far behind Europe. We don't have a GDPR, and we have a number of other constraints that make it pretty clear that Congress is sitting in torpor. So then we're looking at the other branches of government, predominantly the executive branch. So the executive branch has been active and certainly has been pretty thoughtful and consistent, I would say, with regard to an incremental and more specific body of AI recommendations and utilization of a whole of government approach with regard to AI. Of course, controlling for political party of the Oval Office occupant. So it began in the Obama administration in 2016 with 2 concurrent documents issued preparing for the future of artificial intelligence and also the National Artificial Intelligence Research and Development Strategic Plan. Very, very general, just issue spotting that these are important issues. Then in the Trump administration with a slew of executive orders, and I am keeping it concise, Executive Order 13859 in 2019, Executive Order on Maintaining American Leadership in Artificial Intelligence, and also Executive Order 13960 in December of 2020, promoting the use of artificial intelligence in the federal government. And it was the Trump administration that decided to charge NIST, the National Institute of Standards and Technology, with laying out a body of guidance on how AI should responsibly be used. In the Biden administration, there are two key documents that I think are worthwhile. The first is the blueprint for an AI Bill of Rights. Note, a blueprint for a Bill of Rights, not the actual Bill of Rights. So you're seeing the development of technology and use cases and societal change in this subject matter far outpacing the government's ability to catch up. And then I think critically, executive order from February of just this year, 14091, which is a build off of executive order 13985, styled further missing the word here, but relating to racial equity and support for underserved communities through use of the federal government, which has three key AI provisions. One in its prefatory language of Section 1, and two other provisions as well. So looking, let's say, at the October 22 blueprint for AI Bill of Rights, there's a section with regard to AI discrimination, but it's really short. It's like 6 pages long. And then it references the need to develop AI standards and shunts off to an organization called the Data and Trust Alliance, which has its also very short algorithmic bias safeguards for workforce. And ultimately, we are left with a lot of questions and few answers. Now, building off of Commissioner Sonderling's statements, let's look at our EEO laws. Keep in mind that they are premised in voluntary compliance. That's a very big, important point. Because as we're looking at administrative law's operation here, you have an absence of congressional legislation. Bicameralism and presentment is really not taking us anywhere so far, and probably won't be taking us anywhere in the coming months, at least for the foreseeable future. So then you have the administrative state, led by the president, but there are constraints there too, predominantly the Administrative Procedure Act of 1946. So as we know from the last summer in the Supreme Court's issuance of West Virginia versus EPA, the application of what many scholars and commentators describe as a weak version of the major questions doctrine that just concludes, hey, if the statute doesn't authorize this significant major interpretive change from it around the time of the enactment, and a long time has passed since then, the agency doesn't have the authority to interpret the statute in a different way. So that's a guardrail that is really important, I think, that could limit the ability of the executive branch and its agencies of interpreting long existing statutes in a way that expressly regulates AI. However, the government has plenty of flexibility to apply existing statutes where AI has been used for existing circumstances that were the predicate consideration of Congress. Now, there's two different ways in which agencies can regulate, as I'm sure you know. Rulemaking, it's governed by 553 B and C of the APA that requires notice and comment. The benefit is public participation, but also one of the costs is it takes a lot of time to do so. You're looking at a quarter of a year up to a half a year, and then there's of course going to be a lot of follow-up litigation because it's very difficult to do anything in American society today without someone being upset about it and then suing about it. And then you have the other tool that we're seeing government leaning on quite heavily, which is the power of enforcement, in the context of EEOC reacting to charges that come before it. With the power of enforcement, agencies are able to, on a case-by-case basis, determine the lawfulness of conduct that has already occurred and potentially determine its retroactive legitimacy. So this presents a certain advantage to agencies because they're able to move more efficiently, more nimbly, but it also creates some big deficits as well. You don't have public participation with regard to agency enforcement practice. It takes conduct that is lawful or not expressly unlawful at the time of commission, rendering it retroactively unlawful. And because the parties that are the subject or the target of enforcement behavior tend to be less likely to defend their rights fully through the agency and all the way up through the courts, the judiciary are reacting somewhat less to the important questions of the day. And consequently, when regulated parties settle or acquiesce to agency interpretations, or enforcement actions following charges. Then a body of common law is developed, but at the agency level, that agencies sometimes style as precedent. So it's sort of a different level of a dystopian future in one respect. In another respect, trying to take the arguments of what one would, like a left-leaning scholar would describe, I try to keep it middle of the road. The left would argue, hey, society is being affected right now. The Congress is not acting efficiently or necessarily in the way that it should, and the executive branch has enough discretion to cover the gaps with existing statutes, and therefore it's important for the government to step in for the betterment and the welfare of the people, certainly disadvantaged minority classes of persons that are governed under the Civil Rights Act. So with that, I'll take a pause, allow the other discussants to speak, and I'm sure there'll be a lively discussion that follows.
Thank you very much. The next speaker will be David Fortney.
Thanks, Phil. And I'll just remain seated if that's okay. I'm not sure what the protocol is, but we'll go that way. All right. So I want to try to bring in perspective some of the views of what we hear from our clients. We represent employers. We represent employers across the spectrum. Small, medium, a lot of large, multi-state, multinational employers. It is clear that we are in the midst of this radical change. You know, we all changed when we started using cell phones or word processors. The difference is that the pace at which this is occurring is unprecedented, and how it's occurring. So we find all of these lagging factors. And I think Aram's done a very nice job of laying out sort of the regulators, the statutes. So, you know, what is the framework we're working under? On the other hand, obviously the new technology is wonderfully appealing. I mean, Phil's story lays out every employer is thinking, wow, in today's uncertain economic times, my resources are strapped. I don't need Phil Mescamera. I can have ChatGPT. It's great. And I don't need a room full of Phils, you know, et cetera. And so there's a lot of motivation. I mean, recent press, as some of the industries that had scaled up on DEI and put together cadres of humans to monitor that, those were some of the first people that they let go in the current environment within the last 6 months. Not that they're not paying attention, but they are relying more on these machine monitoring, assessments, and recalibration. And I would like to thank all of you for actually showing up in person. This is a very quaint gathering that in 6 months may not be even held anymore. So, but with that, where do we go? Because the law is lagging, and the challenges are great, and the marketplace, the appetite for this is almost insatiable. I've heard some of the government regulators, not Commissioner Sonderling, but others say, well, maybe people shouldn't use it, shouldn't use AI. That's unrealistic. I mean, if you use LinkedIn, you're using AI. If you're using, I mean, AI permeates most of us. You get an email, and you get those 3 or 4 automatic responses now. You know, Vicki Lipnick sends me an email, and I say, oh, that's great. Well, that's just by me clicking one key that has an automated response. So those are all soft forms, but examples of AI, how it has already, we have it. One of the things that we have done in this very uncertain time, when you look at the legal landscape, as has been pointed out, is complicated. So but we do have some federal laws that still govern us. Yes, they're from a very different period. We have this set of guidances called the Uniform Guidelines, promulgated under Title VII. They are regulations for EEOC. They are, guidance for the EEOC, binding regulations for federal contractors and enforced by the Labor Department, and well recognized by the courts. Under the Uniform Guidelines, you can take employment selection tools. So this was obviously written 45 years ago before anyone knew what AI stood for. But you can still take employment selection tools and go through a process, complicated, that's called validated, meaning that it serves a legitimate business interest, it advances that interest, and it does not unnecessarily discriminate. It's an efficient way of achieving the business interest. So think about hiring people, promoting people, how you pay people, all of that. So the question is, can we take these existing tools And those tools are very important to employers because it provides a legal safe harbor, meaning that even if a judge or a jury would find what you did was unlawful, if you can say, look, I had this validated and I followed a validated process, that immunizes you from legal liability. So it's a very powerful concept. Now there's a lot of reasons, a lot of concerns about, well, can you really apply those to AI? That was a question that a group of us had spent a lot of time on as employers were looking at that. And so under the Institute for Workplace Equality, we did ask Vicki Lipnick, and the reason I highlighted her a moment ago, and Vicki, formerly commissioner at EEOC and acting chair of EEOC, to head up a task force. We've got about 40 people, multidiscipline, plaintiffs' lawyers, employer lawyers, IO psychologists, statisticians, data people, AI developers, AI vendors. I mean, we tried to put everyone together in a room. This took 18 months, okay? So this was not a simple process, but to slog through and ask the ultimate question, not as the law might have been, but as the legal tools we have today, can we do things that are positive to apply and be confident in the tools we're using? And the answer is not perfect yes, but largely yes, that most AI tools can be validated, which is a very positive thing, and I want to just sort of put that out there. So it doesn't need to be it doesn't mean that these other legal developments shouldn't be pursued. They need to be. But those are the tools that are in the tool chest today. Complicating the employer landscape is this rapidly developing, it was mentioned before that we don't have federal preemption. So under basic Federalist concepts, that means all the states they are free at it. And boy, they are free at it. Whether it's New York City with its animated employment decision tool requirement that you have to both assess what the tool is and publish the results. This is kind of like the UK pay studies that are in place. You have to publish those, to a variety of states requiring notices to be put out. Illinois, if you're using video, as Commissioner Sonderling mentioned, you have to advise the candidate of that, allow them to consent to that. We have many states that are looking to come online and bring more of these tools on, which may or may not be good, but I will tell you from our client's perspective, when you run a multi-state or multinational effort, the concept, it is going backwards by decades to say, well, I'm only going to do the New York method or the Illinois method or this. And we all faced a little bit of that with California's, I'll call it, we thought a little perhaps over the edge wage hour requirements and who was a contractor or employee. But that at least you could more easily define which segment of your workforce would be subject to the California requirement. AI tools don't work like that. They effectively impact everyone in your organization. You don't have a separate HRI, human resource information system, just for your Illinois workers or your New York City employees. So this, I think, is actually a challenge that we have in conceptually, even though typically we'd say, look, not having a heavy-handed federal regulatory state is a good idea. We have some clients that are beginning to think maybe we need at least consistency. My answer in part is careful what you ask for, because you may get a heavy regulated state, but that's at least one of the issues that's actively being pushed about. And final thing that, and I've got lots more, but I'll save it, Phil, for when we have a discussion. It isn't just the employers that are concerned about the speed and using these tools and the efficiencies that can come. About a week ago, there was the open letter by many of the tech designers. So I think we're up to about 3,000 individuals who've signed this open letter, including Elon Musk, including Steve Wozniak, an Apple co-founder. So these aren't just sort of fringe people. These are people in the heart whose business it is to design and push forward. Basically what they're saying is, you know what, if we go beyond ChatGPT-4, which Phil described a moment ago, if we keep going beyond that, and we are, I mean, it's rolling at a very quick rate, we, the designers of these products, are very concerned about what's going to occur. We think there should be a 6-month hiatus in the deployment of additional tools. It's an interesting concept. Further, they are actually seeking that there be federal statutes enacted to regulate this, to put guardrails on, regulatory requirements imposed, because they've said that effectively, if we just leave this sector to its own designs, I mean, we're just going to veer off and do things that people perhaps don't want. I just quote to you quickly from their open letter because I think that it's powerful. AI systems are now becoming human competitive at general tasks. This is my point. That's why I'm replacing Phil, because I've got someone that can do that. Soon we'll just have a little screen up here as our moderator.
I'd like the videotape to be destroyed as soon as this panel ends.
But they go on and say, should we let machines flood our information channels with propaganda and untruth? That's one of the other problems is there's no quality control mechanism. Should we automate away all jobs, including the fulfilling ones? Should we develop a non-human minds that might eventually outnumber, outsmart, obsolete, and replace us? Should we risk loss of control over our civilizations? These are their questions, the developers of these services. So that's powerful, and it goes on. This is an open letter, and I would encourage you to look at it. But it raises powerful, thought-provoking questions that I think all of us, as members of society, in grappling with what do we do, the automation is continuing apace, and that's kind of their point. The marketplace for using and developing efficiencies is absolutely there, and typically for the best of reasons. But the unintended consequences, which is what I think they're highlighting, are real too. So with that, I do look forward to our discussion, and thank you very much.
And Phil, I knew it was ChatGPT when you said upskilling and reskilling, because that's way too fluffy of a term for an NLRB lawyer.
Well, you know, it's funny. I'll have right back at you, Commissioner Sunderling, with the first question. You know, in the world of the NLRB, some of the leading cases that still deal with technological change involve, in one case, prefabricated doors. That was a Supreme Court case that was decided more than 50 years ago. Another leading case deals with the use of containers in the shipping industry, and that was a case that was decided 40 years ago. And so given the lag associated with, you know, even relatively simple types of technological change, how capable do you think the EEOC is and other administrative agencies to really even attempt to keep up with the type of technological advancements we're seeing now?
I don't think we can, and I don't think you could ever expect the government to be able to keep up technologically with the private sector. I don't think that's the balance of how it should work. I think what we should be doing is saying what we know best and forget whether it's fancy technology, forget whether it's an HR manager who's racist or biased, whoever you want to call that person who's making those discriminatory decisions. What we know is results. And what our investigators are going to be looking at when they go out at federal investigations or lawyers trying to prove is bias in the results. And how he got there is a different story, and how now we prove that through whether it's made through artificial intelligence or whether it's made through a human. I mean, what are we faced with now when we have to prove bias, when we have to prove discrimination? We have to resort to subpoenaing witnesses and deposing people and trying, you know, there's so many people like to focus on the black box of algorithm. If we only had the inside of the algorithms, we'd be able to show that big tech wants to discriminate. We'll be able to show bias, whatever context you're talking in. But, you know, what are we left with now? How do we get inside somebody's brain? All we have is depositions now, and generally everyone's very honest during a deposition. So of course we find out if they made a discriminatory hiring decision through
Usually
deposing
admit that
them.
right after they give their name. Yeah.
Exactly. Of course I fired that person because of their age or race or religion. So in a sense, looking at the, you know, I'm flipping this in the sense where, you know, it's the same true with the cases related to the EEOC. You know, this whole disparate impact theory came out of the 1960s from a Supreme Court case on tests being put that required a high school degree and looked for those characteristics. So, you know, it's no different than that with this technology. But going back, when our investigators show up, we're going to look at results. We're not going to understand. You could show me the algorithm. You know, give us the proprietary AI. What am I going to be able to do with it? You know, it could be changing 100 times. Our federal investigators are never going to have that understanding. But looking at how you got there, in a sense, AI can make that more transparent. So my example now with, you know, how we're left with proving employment decision of trying to squeeze it out of somebody, you know, in a way, if there is a a track record through transparency, explainability, all these buzzwords of how that decision, that computer decision made that employment decision, whether it's here's the skills we looked at, here's where we recruited, here's the data set, here are the applicant pools, here's who had access to the algorithm. That's a lot more transparent than what we're left with now. So in a way, I'm trying to flip the script and say using AI can actually help the EEOC in its mission. It can help us prove discrimination, whether intentional or not, or in a sense from an employer's perspective too, if you've invested in these systems and you have proper policies, procedures, handbooks in place, if you're training those who have access to the algorithm, you should feel confident in establishing a good faith defense or showing what characteristics actually went into with a track record now that's documented digitally, which we didn't have before. So it's just really, in a sense, ignoring all the distractions for us about the technology, about whether it applies. It's saying, here's the result, let's start there, because that's what we've been doing since the 1960s.
Yeah, and I'd be interested, all panelists, David made reference to as one concept, a moratorium in the development of new AI tools for, a 6-month period. Is it feasible from the perspective of regulating artificial intelligence and related tools, is it feasible as one element in the approach to be either to stop it for a period of time or to slow it down? And let's start, Keith, with your thoughts, and then David and Aram.
Yeah, so for my part, if companies want to develop programs that are deemed aggressive, deemed to take down humanity, it's still a free country, and if employers want to use those for the wrong purposes, then there's going to be liability for them. So unless Congress makes it illegal for companies to develop sort of products related to this generative AI, from our perspective, we just have to deal with the consequences of them. So I don't think we should be in the business of telling the private sector of stifling innovation and telling them whether they should create new products or shouldn't. We just have to make sure that whoever is developing them and ultimately using them, who face that liability, understand the consequences of the various laws that it impacts, which is very difficult in that sense because it literally impacts every single law in the book. And I think that's more the challenge than saying, no, you can't do it.
And David.
I think a pause is unrealistic. I agree with that, and I hate to sound cynical, but I'm wondering if the signatories to this letter, if it's just not to assuage their conscience on what they've developed, maybe, but maybe that's being too hard-nosed. But I do think, if the purpose is to allow the law to catch up, look, we're in Washington, we know. 6 months is the blink of an eye. Nothing's going to happen in 6 months, period. The law's been trying to catch up on this, as Commissioner has explained, for years. So 6 months is not the case. Whether there should be a broad-based consensus on whether the laws need to be changed and how to go about it, that strikes me as a more constructive discussion and dialogue to bring in all the stakeholders. There's not going to be a consensus. There's not even a consensus, to Commissioner Sonderling's point, that the current law is insufficient. And I tend to personally be aligned more in that direction. And current law may not cover every single instance, but it's pretty good. But whether there's room for improvement, that's always a discussion that I think we should welcome. I don't think it's realistic to think that you're going to pose a hiatus. I don't think it would be honored, and I just think in the current economic times, with all the demands employers are facing, that will not occur. So we should do something a little more realistic, I think, instead of a hiatus.
And Aram, is it feasible as one element of a regulatory approach, either to stop AI development or to slow it down?
I don't think it is. It's very difficult to do. So first you'd have to have Congress moving with such alacrity. Let's assume that's the case, right? Because Congress moved quickly when there was COVID, right? It did so quite intentionally and significantly, right? You had a federal eviction moratorium that Congress enacted in a severe enough emergency and within our memory, right? So Congress can move very quickly if it wants to. But then the other problems is this creates a slew of other constitutional issues, like contracts clause. Like what if you already have these processes in development, which we do, and then these companies just go belly up if they just can't do anything with it, right? Then at what point is it like a takings, potentially? And there's a whole slew of very complex but important issues that one would need to look at. I think it's economically impossible. My assumption is that all of these, like a ChatGPT, like 8, has already been created. It's probably already been deployed in several sectors. My assumption is that the military probably already has very advanced versions of this stuff already in deployment. And then also, what's the solution, right? Is it a government takeover, or do we establish ministries of truth? And alongside that, does Congress have the ability to regulate the rest of the world? It doesn't, right? So US competitors are still developing this technology and would not subject themselves to this moratorium. So this would just stifle American innovation. Now, am I fearful? Yeah, I am. I've played around on ChatGPT 4. I've utilized Dan mode, which like jailbreaks it and allows it to answer some questions that otherwise it wouldn't answer before. At least I did that with ChatGPT 3. You can just look up Dan mode, D-A-N space mode, and just cut, paste, and then it answers some more questions that otherwise wouldn't be constrained to answer. But I think the solution really needs to be a collaborative one with industry, government, and also Congress to lay out some guardrails at a sufficient level of generality to guide the technology for the best benefit of our society.
And here's another question. The European community had been, I think it's fair to say, in the lead when it came to data privacy over the US. What's happening now in the European community and other countries in comparison to where we are in the US when it comes to regulating AI? Any panelists?
Well, they're trying to get ahead of this like they did with GDPR. And they're taking a much different approach, which is much more complex, where they're saying, we're going to take a risk-based approach to regulating artificial intelligence, and we're going to categorize product use. So we're going to tell you if it is a certain use, depending on the industry and type of product, what requirements you're going to have. And from a low risk to a unacceptable or high risk, and they've said the use of employment is in the highest risk category possible, which subjects it to robust disclosures, auditing, and other requirements as well. What's different over what the EU is proposing, which is different than here in the United States, is they're also trying to put vendor liability in there. And they're saying you're a vendor whether you design, deploy, and put it on the market, or if you are creating it internally for yourself and deploying it, then you have that vendor liability as well, which is significantly different than here. That actually give some teeth to the vendors who are out there designing and developing these programs. So they're saying that, we're going to tell you the use of this product. If it's high risk or low risk, we're making that decision from the government. And we're going to create a new enforcement agency to then go ahead and enforce it at the different member state levels. So that's what's going on in Europe, which is a much more, I want to say, aggressive approach of having a governing body there, but then the government saying, well, here's how we determine how the risk of you using this product.
And let me ask Aram, who wrote an interesting article that dealt with mitigating artificial intelligence bias in administrative agencies. And all of us have some familiarity with administrative agencies. Could you just talk a little bit about your observations regarding bias in administrative agencies when it comes to this area, and what efforts would be constructive in terms of trying to mitigate that bias?
Thanks, Phil. So my concern is that government agencies developing, using, and procuring their own AIs for the purposes of their work. This is already happening with the U.S. Department of Justice utilizing algorithmic tools for purposes of enforcement. EPA is doing it as well, as I understand. And this can carry with it a number of interesting features. One is on the investigations and the enforcement side, you're talking about a domain of executive branch behavior that is actually unregulated by the Administrative Procedure Act. The APA has very, very little constraints, very few constraints on administrative enforcement and investigative tools that leads up to an enforcement action. Once an action takes place, then you're sort of mainstreamed into the APA's guardrails. But before that, that's an issue. Also with regard to grant administration, if it's just a big black box that black box concern. Well, under the APA, you have to have, if it is reviewable as a final agency action under Section 706 and 704 of the statute, it's reviewable for arbitrariness and capriciousness or nonconformity with the law. And an administrative record needs to be generated so that the court can have a snapshot view of what the agency had before it at the time of its decision making. If that information is not traceable, if it's not somewhat transparent, then that presents a significant problem for traditional APA oversight of agency behavior. When it comes to grants, for example, if you have an AI tool helping with that and it is not properly trained, it might essentially become its own policy-making entity, just having outcomes for a particular subset based on how it's trained and not based on the correct statutory or regulatory factors that have been promulgated through notice and comment rulemaking or a guidance document. So I think the domain of AI in government is a really important one. And this is one area, maybe I'm being facetious here, where I'm almost happy that government's a little bit behind because it allows the best technology use cases to be developed in the private sector and then the sound ones to be developed, to be adopted within the government.
You know, and that's interesting because I would say 95% of what most of us see when it comes to artificial intelligence and regulatory issues involves the concern that the use of artificial intelligence represents or constitutes some sort of violation in the private sector, and the government's trying to keep up from a prosecutorial perspective. When it comes to the potential use of artificial intelligence to identify or to prosecute violations, I'll ask this of both Keith and David. What would that mean in terms of burdens of proof when it comes to proving a violation? And what would that mean in terms of due process, in terms of understanding what the basis was for a particular prosecution or allegation of a violation? Commissioner Sunderling, why don't you start, and then David, your comments.
Yeah, I mean, I think it raises really interesting questions when you're putting, additional burdens or trying to change longstanding burdens of proof, which I believe only Congress can do, related to the enforcement of these laws in the civil rights context. And, is there now need to be a higher standard when a computer is making it versus when a human's making it? Do we need to reevaluate that equation? I bluntly think, not, and obviously it's my job right now to enforce the laws that have been on the books, but I don't think that, when it comes to altering any of these standards, that it is necessary at all, because again, it's very simple to simplify it from the position I'm in now. We are just looking at the outcomes of there, and there's a well-established system of getting there, whether it's under various theories of discrimination or, ways to test for disparate impact. Those exist, and I do not believe they should be altered. I do think we should be bringing more light to them and showing how it works with each different use case of AI. And I think that that's the burden on the EEOC and the federal government across the board, whether it's in housing, whether it's finance, any use of this technology or in the criminal justice system. Potentially, I know you could have a whole other panel on the use in the criminal justice system and sentencing and conviction and all that. But from our perspective, it is just so important to go through every single use and show how the law applies. And to David's point earlier about localities trying to get involved in this as well, I think that's also dangerous for employers as well, although they should be commended for trying to take on a very complex issue. If they're not also ensuring that employers have to, in those jurisdictions, have to comply with all federal laws, then they're going to have a problem, because in the New York case, when you're asking to do a bias audit and you're putting new standards for employers in New York City to audit certain pre-deployment audit on certain characteristics, well, then if you're doing it, shouldn't you be doing it on the other characteristics that the EEOC is going to look at either way there? So that's kind of the challenge with other people getting into the space, and also not having a new standard. So the other thing with New York is that, okay, so you're going to require this testing, you're going to require audits, you're going to require that public disclosure. Well, what does that mean? Okay, so the EEOC's been doing it one way since 1978. Now you're putting this new requirement. So here's the million-dollar question: how are you going to do it in New York? And then it's been delayed, and then ultimately they come out with some guidance that says, well, look to the EEOC. And especially with their disclosure requirement, and say, what does that mean? We're going to require you to disclose, which employers haven't had to do before. If they find bias, does that mean, oh, we found some discrepancies and we fixed it, or our program horribly discriminates against, you name it, Hispanic women, whatever it is. So, those, when you're starting to layer on different requirements, whether it's through your original questions on the burdens or what you have to do, without that uniformity or without the going back to the basics of what the EEOC requires, you're just causing basically significant confusion and more harm than good.
Yeah, and David, same question, and I'll expand it to include private litigants. To the extent that you have violations that are alleged to be proven using artificial intelligence tools in a courtroom or by an administrative agency like the EEOC, what does that do in terms of burdens of proof? What's that mean in terms of due process considerations?
Sure, thank you. It's a thoughtful question. Now we're getting, as they say, down to the nub of it a little bit, because this is where it comes to play. So we have this multi-tiered, very complicated legal landscape. The states, I think, largely are tracking basically what the European model is: transparency, disclosures, audits, and consent by the participants.
Which, by the way, there's nothing preventing employers from doing that by themselves.
There's nothing preventing employers, and some of that, I think, is a best practice, but it's not required. So that, in terms of states, from an enforcement standpoint, Phil, that makes it easier for states, because that's a very checklist type of item. Did you publish that you're using this tool? Did you give people a chance to consent, to opt in or opt out, et cetera? And respectfully, I think most state agencies, they can kind of handle that. I mean, it may be hard for our clients to comply with that or understand or interface with the federal, but the states, they sort of shrug and say, not our problem, And in our Federalist system, we live with that at the moment. So we have to live with that component, and that, as I've indicated, is changing very rapidly. Then we have the federal system. Most of the laws we're dealing with are focused on employers. And most employers are not the ones building these tools. They are customers. They buy these tools from AI development, from vendors who develop these tools with all sorts of things. And as Keith mentioned, they have a black box component. I mean, your typical company, they're like, I need more efficiency in screening because I get 5,000 applicants a day. And I laid off 3/4 of my HR department, so I just need some process to get through that efficiently. And you know who I want. No, they don't all need to be lacrosse players, but I want people that can get this job done. That is largely what many companies are looking at today. So they go, and there's a variety of tools out there that say, we'll do a good job in scraping through applicants or going out and finding people and tapping them on the shoulder and saying, don't you want to apply? Through various job boards. And so when the burden of proof comes, when a company, if they're faced with, let's pretend hypothetically it's the EEOC, they say, well, we're very concerned because your hiring practices indicate X. How did you come to pick those people? And depending on the particular AI tool that's being used, it's like, well, we went forward with bona fide requirements for a job. And we said, these are the people we want, these are the vacancies, and help us rank. And yeah, we did interview people, and we told people it was a Zoom call, and they all wanted to come. No one wanted to fly into headquarters in Seattle to talk to us, so we interviewed them all on Zoom, and here's who we picked based on that. Very simple. That could be problematic if the problem came through the, quote, black box, and the burden is on the employer because you use the vendor's product. There's one other development, though, that I think both plaintiffs and maybe EEOC is starting to pivot a little bit. The employment discrimination laws primarily focus on employers. They also focus on employment agencies. And I like how Keith approaches this, which is, let's go back where we didn't have machines doing this, but you go to an agency and said, I need a laborer. I need someone strong and maybe from this neighborhood would be great. So you have, and the agency only gives you resumes of,
And same with the unions as well.
unions, et cetera, that fill those discriminatory requirements. All right. And clearly, the law in 1964 was designed to say, we don't want that to continue. We recognize that practice. Terrific. That's on the books. Now, today, some of the tools, at least as alleged, EEOC settled a case within the last week against DHI, in which the allegation was that the AI tool was being used to discriminate. It was a job board, and anyone could post on the job board that wanted to, but they alleged that the DHI, the job board tool, would allow discriminatory postings to go forward. So the settlement was that they had to affirmatively use AI to ensure that none of the postings were discriminatory. Kind of a page out of the Facebook settlement involving discriminatory housing. We're going to make sure that the ads aren't discriminatory. Another case, Workday is a very popular human resource information system that many employers use to do a whole variety of tasks. Workday has been sued in private litigation. The EEOC took a pass on this one. They decided not to go to charge, in which the plaintiff says, literally, I applied to 80 or 100 companies that I think used Workday, and I didn't get a job. And I'm a member of, he's over 40, African American, has disability, he has a whole litany of things. And therefore, I think Workday is what caused this to occur. And I'm not suing the 80 to 100 employers, I'm now going to directly sue Workday. Stay tuned, it was just filed. We don't know the outcome yet of that, but it shows to the burden of proof and innovative ways. It's kind of like how water finds its way in. These claims are going to come forward. The law may or may not be outdated, but so the attack point is getting to the vendors. The vendors are in the best position, typically. Employers are primarily on the hook. It can be hard to defend, but the employment agency theory is one that's developing rapidly and is worth following.
Just two questions before we open this up to the audience for questions and answers. And by the way, you think that I'm speaking, I'm just moving my mouth. My cell phone is set to the Google Bing search engine, which is actually generating the audio right now.
What is your ATM pin?
Black box question, number one, is, and I'll direct this to Aram and David. Everyone regards AI, the kind of essence of AI is that there's a black box, that the algorithm that does a lot of stuff, and it's not necessarily uses the same type of logic that any one of us uses. How many products are out there in the marketplace right now that you think basically don't work? Meaning they don't perform the function that they are advertised to perform. And not necessarily the result of any intentional misrepresentation, but we're kind of in the Wild West right now in terms of publishers of various tools and AI products. What do you think in terms of just how many products are out there that are not, putting aside legality, may not actually be performing the task that they are purchased to perform or licensed to perform?
It's a really good question, Phil. A technical one that I don't know if I can really conclusively answer, but I will say that if you have proprietary software, you have a lack of understanding within society, there's no subject matter regulation by government, and it really comes down to just private contracting between parties. There's no real way of knowing. I think it comes down to the successful market incumbents being able to prove that their products work. And I bet that, at least in the context of AI and HR, most firms aren't just going to jump into replacing their entire processes with an AI product, hopefully without engaging in some sort of due diligence. But there probably is like a subset of firms that don't do that, and that's a big problem.
Yeah, David, what do you think?
I think there's a lot of, I'll call it unintended consequences. many companies and these researchers and software engineers and so forth, they say, look, what do you want? I want pay equity. I want to be fair in hiring. Okay, so that means that I'll make sure every time you hire someone, I'll check and see how I'll calibrate my hiring decision for you. The AI tool does this. You're kind of underutilized in terms of women in these engineering roles, so I'll just, through the tool, tilt a little bit, and I will effectively suppress some of the male qualified applicants and really hone in on females. And I'll just get those numbers right back up to where you want them. That is largely what we have found, because people are like, wow, I started using these tools. I'm great. I've got pay equity. My hiring numbers are spot on. I had 42% female apply. I hired 42%. It's perfect. I'm absolutely perfect. And those are flags. And so the only way, in my experience, you can get that is that there, in fact, is either enhancement or suppression, which likely is unlawful, but it occurs, albeit for the best of reasons, but it occurs. And it's very hard to find out how. And in my experience, I would like to think that the clients are being more careful. Honestly, the corporate lawyers tend to be the last ones that are checked off. The compliance unit, the compensation unit, HR, they're like, hey, we got this new software we're bringing online, Q2. And the lawyer's like, what? What is this? Oh yeah, we signed a contract, we're good. In fact, it's gonna be great. You're gonna love this, because you're always saying how bad our hiring numbers are. We fixed it. We went to that retreat with you. This is literally in the last 2 weeks, a conversation with a client. We went to the retreat, you were all over us, we had to get it fixed. We went out, we spent $250,000, we have the problem solved. And we're now trying to unpack and figure that out. And it may not be quite as good as advertised, but I don't think it was done badly, but it was,
And now our corporate logo is on all the vendor sites, so the plaintiffs' lawyers and class action lawyers and the government can see who's using what.
So that's, and I agree, we can't quantify, but those vignettes, I hope, bring to life some of the concerns.
And last question for Keith. This is another black box question. You know, questions about validation. And we know that selection tools that use artificial intelligence have an aspect of them that is enigmatic, because we don't fully understand why it is that they produce outcomes that are more successful than human beings historically have been. But when it comes to validating a process that has, in its essence, something that's very difficult to scrutinize with logic, when publishers or the distributors of these tools say they've been validated, number one, is it possible when a technology didn't even exist 2 or 3 years ago for it to be validated in the conventional way that would pass muster with the EEOC? And in general, is validation, when you're talking about selection tools using artificial intelligence, is it the same type of validation that employers have used for the past 30 or 40 years? Or does it really have to have some different type of validation because it's a different type of selection process?
Well, you know, kind of tagging off what you said here, there's so many products out there that, and maybe this is outside of our wheelhouse, more for the FTC, that say we're EEOC certified and we're OFCCP certified because we've done these testing in the aggregate. And we use generic BLS data to show that this engineering position, applying through, you know, through fake company for advertising purposes, that we are in compliance with the 4/5 rule, and they really quote the rule, that it's completely binding. And in the sense is, you know, that is also just not true, because when the EEOC is going to look at the validation related to one of these tools, they're only looking at how it applied on your workforce in that location, on that job description. And that requires going through every single line of that job description to see if all those requirements are necessary, if they can be validated, and what that actually looks like. So when you have the sales process of this saying, well, there's these long-standing tests that the EEOC and the OFCCP has used, and we've paid these either academic or private studies, these IOs or accountants to look at this, to taking a generic data set, and we're okay. Well, look, the law allows 0% discrimination. And although there are methods of proving disparate impact that do allow, some wiggle room as a defense, at the end of the day, when you're actually showing up in court and you're showing up in the EEOC, you don't know what method of validation you're going to get, because the EEOC doesn't always use the 4/5 rule, and neither do plaintiffs' lawyers, and neither do judges. So it really becomes a battle of the experts of whose test shows better for results for what they're looking for. But at the end of the day, very similar to what we've been talking about, all those aggregate studies, all those testing methods, which I think apply equally to when employment assessments were on Scantron with a pencil. At the end of the day, it only matters how it's applied in that one workforce, in that one job position, and that is totally lost in the advertising equation and the implementation equation.
Yes, and I think we'll open this up to other questions. By the way, I also want to acknowledge that former EEOC Commissioner Vicki Lipnick is also in the audience, and I intend to ask her all of these questions privately afterwards, because I'm interested in what Vicki has to say as well. Yes?
Hi, excellent panel. Thank you. I've learned a lot here today. My name is Adam Thier. I'm a senior research fellow with the R Street Institute here in Washington, and I'm also the head of the Regulatory Transparency Project Emerging Technology Workforce. Last November, we came out with a study on the coming onslaught of algorithmic fairness regulations, where we surveyed the kind of things that David was discussing in terms of state and local efforts that are multiplying like gangbusters, not just on the employment front, but on every possible conceivable front. Some are narrow, some are broad-based. So we actually have a survey out there, and then my co-author, Neil Chilson, and I are going to come up with a follow-up study for FedSoc highlighting these points. And I want to build on that point that David made and that Phil just asked the panel about, to tease out a little more detail about where we might be heading and get your opinions on where we're going to see policy going over the next 2 to 5 years. Which is that when you look at all the state and local activity on this front, again, not just on the employment side, but on all algorithmic fairness issues, all roads lead back to some kind of call for algorithmic transparency, algorithmic explainability. Let's get under the hood, behind the black box, whatever your preferred metaphor. And the preferred regulatory vehicle to do this is some sort of algorithmic impact assessment or AI audit. And there are important differences between those two tools. But what keeps them what relates them is the idea that some body, it could be a government body, it could be a private body, a certification agent, could be the courts, somehow certify or put a stamp of approval on the idea that you actually did reveal something about the algorithm to the public. This could take a regulatory or legislative overlay. The privacy bill that's been pending now for a while in Congress has an entire provision about algorithmic impact assessments being mandated. The Algorithmic Accountability Act bill that's been proposed would create a new Bureau of Technology at the FTC to oversee the process of algorithmic impact assessments. The state and local bills, New York, Illinois, others, they have some sort of process like this. So I guess the question is, and this is something that the Commissioner teases out in his excellent recent law review article on this issue, is this question of is there an alternative framework that we can be all right with that would suggest that, yes, there's something to the idea that assurances, audits, impact assessments can help validate or build trust in algorithmic systems, but that it's done in a more decentralized, flexible, agile fashion through maybe a voluntary self-certification process, or better yet, a professional body or association, and there are many out there that are doing this already, creating frameworks for impact assessments and audits, that would then get some sort of light blessing from regulators, whether it be the EEOC or somebody else, and maybe even some sort of a safe harbor from further liability. And this is something I know, Commissioner, you have a brief section on this in your law review article. I thought maybe you and the panel could talk about, is this where we're heading? Because, of course, the EU has a much more heavy-handed prior conformity assessment process. California and other states want to go very aggressive. But what I'm asking you to say is, tell us how we get halfway there and satisfy the concerns of those who call for algorithmic fairness regulations without full-blown, heavy-handed, top-down precautionary principle kind of mandate.
And your work on this topic, everyone should read. I highly cite to it, and I think you're doing great work as well in the points you make. This is a really important concept that I like to discuss, is that there's nothing preventing employers or vendors from doing this now in advance of any of these threatened regulations, in advance of any threatened lawsuits or EEOC investigations. In the employment context, employers have been doing internal audits for decades on the wage and hour side, on the independent contractor or employer side, and they fix it if they see issues in advance. And that's a big part of our mission at the EEOC, is also not just to remedy employment discrimination, but to prevent it as well. And there's long-standing tools for employers to do that. Depending on the content, even in the EEOC context, with the Me Too movement, we couldn't bring every single case on sexual harassment, but because of the publicity that gotten, largely because of former Acting Chair Lipnick's raising awareness of this, the EEOC put out guidance best practices, and what it caused is HR departments to take this seriously. It caused the CEOs of boards to say, it's okay, we're going to invest in this, and we're going to be very public, and we're going to have open door policies, we're going to have new policies, procedures, we're going to audit, we're going to do everything we can to eliminate this problem from happening or occurring more. So in the HR sense, in the labor and employment sense, this is happening constantly within corporations right now, and whether it's being done by internal counsel, outside counsel, a combination of accountings. And that's what I'm trying to argue here when it comes to AI. Because, as you've heard at length of this panel, for the time being, a lot of the standards, burdens of proof, whatever you want to call them, are the same. You can start doing that before you ever let one of these tools make a decision on someone's livelihood. Okay, you can do that internally, whether it's in a combination with the vendor before you buy it, or after you buy it with their assistance and pre-deployment. And that just puts you in a much better position than a company who buys the advertisement, who says, oh wow, you hired some study and you show that this product doesn't discriminate, and it's validated in your sense. Well, now I can just implement it like I do other software, which is how it's being sold, because you're saying, okay, companies spend hundreds of thousands of dollars, millions of dollars on this product, and like other products, it's supposed to just let it go and it's going to be more efficient, economical. But here, when you're dealing with civil rights and AI, you have to make sure that you're doing those compliance things in advance, or you can really, in a sense, violate the law pretty quickly and easily, is some of the examples you heard from now. And my point is, if you do that now and the EEOC comes, or class action lawyers comes, who's going to be in a better position? Company A that says, well, we just bought this, look at the glossy brochure they gave us. They said it was validated, they said they used the EEOC's method, and it works great. And it promised me diversity, equity, inclusion. And I don't say that in a joking fashion, because that's what these programs promise, as David said, why the business functions are buying them, not the legal review, are jumping to them because it's promising pay equity, it's promising all of these things which are top of mind for board of directors right now. So we just let it go and it horribly discriminated against. Versus company B says, we took their advertising, but we know it only applies to our workforce. We did pre-deployment testing. We saw there were some issues. We try to correct it. Whether it's the skills, whether it's where we advertise for the job, whether the qualifications, whatever the metrics are you're looking that you can deal with internally for that specific job, because it's that specific. We found some discrimination, we fixed it, or we're taking the risk that under the 4/5 rule, it's at 96%, and that 4% leeway, at least we've done that testing in advance and we have it in our file. Who's going to be in a better position when we show up? The company that bought the sales position or did all this internal work? And that's no different when you're facing a wage and hour audit, a pay equity audit, an H-1B classification audit, you name it in our space, OFCCP, David can talk to you. It's no different, but for some reason I don't see that happening yet. I'm encouraging that to happen, and that's something corporations can do right now, not just on the testing side, but also on the employee handbook side and the fair use of side, and I alluded to that before. Who are you having access to these algorithms? How are they being trained? And if you have a corporate policy internally, very much like you have a sexual harassment policy, versus, anyone can come in and play with it, again, who's in a better position? And that's all you can do right now. And there's nothing preventing companies from doing that yesterday. And that's what I've been encouraging in the meantime. But instead, everyone's distracted by this, is there a new agency? What's New York going to do? What's the EU going to do? The algorithm's proprietary, so no government can get it. It's all nonsense.
Can I just tag on to that? The Institute report that I mentioned by the 40 experts has a nice list of best practices agreed to by that very diverse group. And I think that would build right out on what Keith just outlined. Thank you.
Well, please join me in thanking our guests today, and thank you to all of you who are watching at home.